Well, I think that that's a possibility. The hearings panel may decide that, but it doesn't. I think the council, if it has a different view to what is in the plan change, has a duty under its, I think, in reviewing its district plan.
But we've done that through our submission. Presumably, this is what we've put in our submission. It's
consistent with our submission, as I understand it.
Yeah.
Yes. But, I mean, Mr Matheson may have a better idea than I have on this, but...
Well, what Ivan is saying is that it would appear that the ministers would prefer that we go the simpler way and simply have one set of rules to consider, or the hearings panel has one set of rules to consider, and that's the plan change. What we're saying is, legally speaking, we do have this right to also...
So no, and we legally speaking had the right to do the same with Littleton, but we're not doing that because it would be silly to do that. So I just want to know that this is the right decision to make. But I think there may be a difference of view around the table, so can we just defer this one to Friday?
Yes.
Yeah, okay.
I mean, is that last time we were briefed on the private plan change, we heard that the submissions from the applicant were significantly different to the notified plan change.
Mm-hmm.
So that raised a whole other point of law around how much you could actually vary what was notified. So when it comes back, I mean, I'm happy to deal with it today, but if you don't want to do that, then, I think we need to get some update.
No, well, I didn't know that. So are you saying that the submitters on the plan change, the proponents of the plan change have actually submitted a different outcome than what they've actually proposed?
Yes, I can't answer that question. I'm sorry, but
well, no, but if that is the case, then that is the basis for putting this in.
Perhaps, Madam, there is two. Yes, the submission lodged by the applicants for the plan change is significantly different to what they actually proposed originally, so it's almost like another plan change. The difference also between the port and the mail site is that the port, of course, is subject to a land use recovery plan.
That's right.
So that's the reason why, in that case, the councillor said there is a process that will get inserted into the plan.
Right.
Our difficulty with the plan change is that the applicant can actually withdraw the plan change even after the hearings panel has made its decision.
Right.
Which would then leave us with a void if they were to do that, and that would put the council in a very legally difficult position because it actually has not done a review of the district plan.
Okay, all right.
So I'm very clear that we need to do this and we should do it.
That's good. And but I think that it is really useful for us to explicitly say why we're doing this, and I think that it would be worthwhile even. Myself writing to the Minister to explain why we haven't accepted his recommendation on this, and it is because if it's got a legal basis, as you've highlighted, then that's a very good position for us to be.
We need to secure the council's position. That we are.
We'll do that.
Yeah, okay.
Community to make submissions, which they otherwise may not have.
No, that's fine. Okay, so that's that one. Yep. What's the next one?
The next one is the motorway. I haven't got a map to show you, but the motorway cuts across one of the greenfield industrial areas, and it's sort of part of the corner. We haven't rezoned, even though it's a priority area in the LERP. The Minister or the Crown's recommendation is we should rezone that area. However, there are some significant traffic concerns if we rezone that piece of land on the other side of the motorway. And secondly, and this is my view, is that the motorway provides a much more robust urban boundary anyway. We're not talking about very much land that has been left out of our proposed rezoning. So the recommendation is not accepted on the basis that access to this land south of the southern motorway extension is constrained by the proposal for a part of the Springs Road to be. So there is a traffic issue as to why that we don't, and a site-specific issue as to why we shouldn't be rezoning that land on the other side of the southern motorway.
Right.
It's a very site-specific issue.
Yep. All right. Yep.
Provide recognition of the inland port. This is supported, so we're agreeing with the Minister here, really. So,
Yanni?
yeah.
See that in stage 1 we've had height limits removed from the industrial heavy zone and changes to provisions for setback from internal roads. I recognise that this inland port will be a different in terms of its activity, but I am concerned that, again, for those existing businesses in that area, and actually it's not too far from a residential area, but if you had things like noise happening 24/7, for example, beeping of cranes or whatever equipment's being used, if you had height that was just visually intrusive along the significant landscapes that support hills, I mean, I just think, you know, we actually need some level of protection rather than just an open kind of canvas for the port, and I don't see where we're going to get that protection if we insert this new policy.
Well, it's for the standards for the zone, for the actual industrial zone. There will be standards about height and noise that will apply here. This is just a new policy that's been put in. It's not changing the development standards that have to relate to the port, the inland port.
So when you talk about potential for reverse sensitivity effects associated with sensitive land uses, what does that actually mean? Does it mean the people that are currently there, if suddenly they get, you know, 100 containers stacked on each other, don't have as much right to say, actually, we're not happy about that?
That's correct. But being a heavy industrial zone, and I'm only going by what's written here, it seemed to me it's probably less important than the need to have those 100, those containers stacked on one another. I think it's a balancing exercise and having regard to the environment that it's in.
But look, it's 10:27, and this is the policy wording that's going on. Is there an objection? There is. So we'll deal with it on Friday.
Okay.
Okay?
And that's it.
It's under you. And
So,
is there anything in definitions that's going to be controversial?
there are a few amendments we need to make through a recommendation, if you're okay with that. I'm fairly certain that the amendments were the actual minister's comments were fairly straightforward, but perhaps Janine will take you through the few changes she needs made through a recommendation, please.
Yep.
Yeah. Just in relation to recommendation 147, I had included in there a short list of definitions that were to be deleted, one of which was port activities. Obviously, with the resolution last Tuesday to remove the port provisions, the additional definition of port quarrying activity also needs to come out. Also, warehousing and distribution activities is another definition in there that can be removed in response to the Minister's request about minimising the number of amended phase 1 definitions. The second point, that was the second point. The third point, the last recommendation about comprehensive consent, I've subsequently been advised that the year period should be 10 years as opposed to 35, so it's more in line with the 10-year operation of each plan. And that was one example, as is the definition of temporary activities in buildings, where they apply to both the general rules and procedures chapter in stage 2 and also the relevant provisions in the Central City chapter in stage 3. And basically what I'll be doing is replicating that definition specific to each of those provisions in each of those stages. And that fourth resolution says effectively that it's just making each definition specific to the stage in which it appears.
Yep. I'm happy to move that. Seconder? Seconded? Phil? Yanni, seriously, are you going to raise some issues about this recommendation?
What's in the definition chapter? So
No, just these recommendations to tidy
okay.
up technical changes.
that's fine.
Can we do that?
Yeah, that's fine.
I'll put that motion. All those in favour say aye.
Aye.
Those opposed say no. That's carried.
There is one more section that we haven't covered, which is signs, because
Yes.
we were waiting for Councillor Johansson.
We've done the maps, haven't we?
The maps we've been through as we've gone, as
We've gone
raised
through them.
things,
So
unless there's
signs is the
anything.
only other one.
Right, just
That
the definitions.
No, we didn't need anything else with the definitions. We've already done that chapter. This was technical changes that needed to be made in response to.
Got a whole bunch of text.
We've
that's
already
been
done them.
Put in. When did you do that?
Well, we did them last week, didn't we?
No, we didn't do the definitions last week.
I thought we did.
No. That's why it's on the list today.
So where is it?
Page 170.
It's quite significant. And
So let's just go through them one by one. So recommendation 144. Anything there? 145. 146. Sorry?
oh, sorry.
Not 146, 147.
147. Yeah. I just want to understand what you're kind of proposing. So if you look at community facility, for example, you've got a whole bunch of red stuff that's taken out, and then you've got things like entertainment facilities. But then you say it's not excludes privately owned recreation and entertainment facilities and restaurants. And you've got a whole bunch of things called reliant definitions. So I just want to understand, are we making it easier for more activities to happen in residential areas?
Basically what this particular recommendation is about is in stage 2 there were originally 41 definitions which were effectively an amendment of some of the phase 1 definitions. And the reason for that is that in some cases it was the stage 2 chapters that were or should have been more appropriately driving the wording of those. In other instances it was to better align phase 1 definitions with new phase 2 definitions. In other instances it was as a result of legislative change to an amendment that we're relying on in our district plan. Obviously, that did create somewhat a confusing situation for any user of the plan in the sense that there would be 2 definitions named the same thing but slightly different. What the Minister has said is to try and minimise that type of confusion. So what we did is we went back and we revisited those 41 definitions to see whether they were really needed. Some of those we've decided that can subsequently come out, and those were the first we list, starting with guest accommodation. There was a second set that we've made the Independent Hearings Panel aware of the need for those amended definitions, and they're going to be considered in due course as part of the hearing on those. And there was a third set whereby we were effectively able to render them new definitions applicable to specific chapters within stage 2 only, and those are the ones that start with that community facility definition and have the red text. Basically what the red text is an indication of how the phase 2 definition has changed from the stage 1 definition, and the black text is where we've endeavoured to make it more specific to a particular chapter or provisions within stage 2.
So I'm just really trying to understand if the changes to the definitions lead to a more permissive, enabling plan at the expense of the community being aware of new or other activities being easier to be done without notification. So things like car parking as well was the other one that I had. Provision of car parking to a temporary activity.
Yeah, I can't actually really comment on the effect of the changes of the definition. It'd be better to direct those questions to the respective chapter leader.
Yeah, that's the thing, is that a definition isn't a decision about the context to which it is applied.
Yeah, so like a temporary activity, if you've now included that to include workers' accommodation, that has a huge...
It's always included workers' accommodation. It's got...
Well, I'm just reading the stuff in red. Use another example. the temporary raising of buildings for foundation repairs or whatever. So that's what I'm trying to understand. Is any of the changes that you've got in the definitions changing materially any of those chapters in terms of what notifications or requirements?
No, the notifications aren't in the definition section. That's why I'm just concerned about this. I mean, it's 10:35. I said I would end this meeting at 10:30. So is this necessary?
They're really just trying to
Can we
make
give
them
Councillor
more
Johansson
fit
an
for
absolute
purpose.
assurance that these changes do not change the operation of the district plan?
Well, each of the chapters you have been through and raised issues as you've gone through. All this chapter is trying to do is make everything consistent between the stages and make sure that the definitions actually work. So this is quite straightforward. Any issues that you would have picked up before, you would have picked them up going through the actual chapter that the definitions apply to. And then the last subject is signs.
Yeah, so, sorry?
Oh yeah, that's cool.
We saved signs for you,
Thank you, I
Yanni,
really
because we knew that you were concerned about it. But
Page 50.
I'm going to allocate 5 minutes more.
Yeah.
I mean, I can't give up any more time this morning. I've got 1,001 other things to do.
Signs is an area where the Minister's comments have been very helpful to us.
Page.
Yep,
150.
150, yeah. We agree with basically everything and have made the modifications accordingly. There is one minor point where we don't agree, and it just refers to how we monitor signs from the Electoral Commission and NZTA. Or they're monitored under Section 35 of the Act. There haven't been an issue, so that's and generally that we have adopted the Minister's comments and clarified accordingly, and they have been helpful to us.
There's changes on the second page.
Yes, there is a change on the second paper where, in the interest of further clarification, we've just made a slight change to the airport zone with signage. We've split the, we just recognised there are 2 precincts as part of Plan Change 84, the aviation and development. And basically, we're just basically saying that in the aviation precinct, which is where all the aeroplanes fly around, there's no requirement, there's no controls over signage apart from health and safety reasons or operational reasons. And so that's again, we think a relatively minor change.
I beg your pardon, it was page 51. I had read the wrong number.
Yeah, I was just-
It's only a few pages and it is straightforward, the one change there.
Right, questions, Yanni?
So just in terms of the changes, whether you've got anything that's been removed in regards to the cumulative effect of signage?
I don't think there's anything removed as far as cumulative effects.
So where you get like 3 billboards in one intersection, which is currently allowed,
You need to look at this.
under the rationalisation of the rules, is there anything that would,
There's nothing in the changes that we're promoting in response to the Minister's decision which affects cumulative effects.
is there anything in our plan that addresses cumulative effects?
Assessment matters. I think we had this discussion last time. I think there were in the assessment matters.
Yeah,
That's
they
when I
were.
read the matters of discretion, whether or not to grant consent, and I go through all those things that you've got, I can't see anything that talks about cumulative effects. Or maybe it's 11. Is
It's
that-
got 11, whether the nature of the signage is such that it will combine with
Yes,
existing
11.
signage on the building, the site or in the vicinity to create visual clutter or set a precedent for further similar signage.
And you're not weakening that in any way.
I think that's the same wording that was there before we rationalised those assessment matters.
Right. I think that's good. I wasn't sure on 6.8 what you're doing there.
Which page are you on?
Oh,
Sorry?
that's just recommendation 20.
Recommendation 20.
Up here. Additional following committed. Oh, okay, so the minister's comment there was we should decide whether we're going to have all the signs under general city rules or have them in different zones. I mean, they picked up that the residential zone, the utilities had their own signage rules. So what we did, we put the utility signage into the general city rules, into this chapter, but we felt from a user point of view it was much more sensible to have one or two signage rules in the residential zone, because they refer to things like home occupations, and if you're doing a home occupation, it's probably better to have the sign control there than it is buried amongst the general city rules. So that was just
So we're not reducing the signage requirements?
No, we'll shift that particular recommendation is to move them.
All good? So that's signs, all done.
So, Madam Chair, apart from the few things that we've set aside to come through to you on
Friday.
Friday, that's
Yeah.
it all
Because
done.
Friday's a public meeting, isn't it?
Yes, it is.
Yeah.
I'm just not sure that, and for Friday too, I just want to, the hospital zone and stuff, we had some discussion with that. There's some other, for example, on page 156, there's more. I just wonder if we might be able to include that perhaps briefly on Friday. I don't know.
We ticked off the
Yeah,
hospital zone.
Yeah.
What-
My understanding
Did
is
we?
that you were we did go through that today with Jacqueline.
Yeah.
Okay.
what's,
No, I just hadn't had time to go over that, that's all. And I was aware we did some of it, I wasn't aware we were taking it all.
we had a good discussion around the underlying zone for Princess Margaret
Yes, we
site.
did. That was probably the main
Yeah.
concern I had, yeah.
All right.
So apart from that, we're through then?
Yes,
Yeah.
apart from, Madam Chair, once we go through the last remaining factors, we should go back then and go through and accept each of the recommendations, the
Yeah.
overall recommendations for notification as well.
Well, yeah, but then, I mean, we can do that in a single motion. But
Yes,
if you
that's
could bring
correct.
that on Friday, but
Yes.
just basically adopt the recommendations with the exceptions of the individual recommendations that we've made on the way through.
That's
Yeah.
right. There are a series of simple ones that you can go through just at the end of
The fewer the better.
stage 2. Yep. Thank you very
All right.
much.
So we've got
But we're publicly
the timetable
notified
now
Friday,
for Friday,
don't
and we.
Yes, except that we will start
Okay.
with the
Yeah.
stage 2 matters that still need signing off before we get into the stage 3 matters. So
Okay.
they're for completely different purposes.
Let's have a look. I'm going to adjourn the meeting.
Thank you.
So, because I actually wonder, because we're starting the district plan at 9 o'clock, I actually wonder whether we should adjourn this meeting until 8:30.
That would be wonderful.
And then we could get this done and dusted and go straight on to the district
That would be
plan,
wonderful.
review subcommittee meeting to deal with the chapter 3 stuff. Now, I'm just, I'm concerned at the amount of time, and I know that I've taken some time out for a global wave for the non-proliferation discussions overseas to support that. So we're going to do that at, I think, 12 o'clock. We're going to set some time aside
Yes.
for that. And
There
we've
has
got
been.
some people coming in from outside to speak on the issues of peace and non-proliferation of nuclear weapons. So we've got quite a busy day. So again, I'd like us to be very focused and see whether we can move through the day a lot more quickly.
Stage
Because we've done quite well today.
Yeah. Stage 3, Madam Chair, is presentations to you because you haven't seen any of these chapters before in
Right.
Stage 3. So it's a different scenario to what we've done for Stage 3. It's a different stage. It's going back to being sure you're aware of what's in the chapters in the Section 32s before they go across to the ministers.
Okay.
That's what Stage 3 is at.
Okay.
I
stage
haven't
threes.
got the date in front of me,
Okay.
I'm sorry.
Yeah, that's
but,
they're all part of
it's
the
all,
stage
it's all,
threes.
It's all very carefully set out in calendars so
Yeah.
that we can meet the notification on the 27th of June.
Yep, that's
Stage
brilliant.
3.
But I have to say that, in terms of timing, timing is everything, as I will often say, for a variety of purposes. But to have all of this, in our sort of diaries at the same time as we're trying to do submissions on the long-term plan, etc. It is horrendous. But anyway, hopefully at the end of June we'll get some respite
Yes.
for maybe a few days.
Well, in fact, by the end of June, this will be well out of your hands, and
Yeah.
apart from giving you updates on how hearings are going, that's all you'll hear from me.
Yeah, that's great. Good. All right,
Thank you.
adjourn the meeting. Thank you.
So Friday, we bring all those documents.